Firstly, good afternoon, everyone. Thank you for joining today's webinar and a very warm welcome. The sun is starting to creep through the clouds here in Edinburgh. It's a Friday, and I can tell you that the air is thick with anticipation about the proposed reforms to the Electricity Act 1989. So hopefully this is a productive use of a small part of your Friday afternoon just to hear a little bit more about what is proposed, and I think most importantly, what does it mean for your project? My name is James Gibson. For those of you that don't know me, I'm a partner in the planning team here at Eversheds, based in Edinburgh. I specialise in energy infrastructure consenting. I'm delighted to be joined by my colleague, Jerry McNally. Jerry is an associate in the planning team in Edinburgh, and a fantastic new hire into our expanding energy practice here in the capital. I'm conscious time is tight. We have 30 minutes of your precious time to walk through the reforms. I think for that reason, I'm not envisaging that we'll have time for Q&A as part of this discussion. However, by all means, use the Q&A function on Zoom, or alternatively, please do drop myself or Jerry an email after the session. We'd be delighted to hear from you and very happy to share any further insights. So without further ado, let's get started. If I could jump to the next slide. So firstly, just some very brief scene setting about the proposed reforms. Firstly, I think it's really important just to make the initial point that these changes are exclusively to the Electricity Act 1989, so to Section 36 of the Act, the powers to construct, operate and maintain a generating station, whether that's an onshore or an offshore generating station. Section 36C, the power to vary an existing Section 36 consent, and Section 37, the powers to install overhead line. It's also worth mentioning this is a consultation by the Department for Energy, Security and Net Zero, DESNZ as it's more commonly called. The reason that this is a DESNZ-led consultation is because we're talking about amendments to the Electricity Act 1989, which is an act of the UK Parliament. So whilst the Scottish Government has powers to determine applications under the 1989 Act, the power to actually make legislative amendments needs to come from Westminster. It's worth also mentioning that a number of the changes proposed here do draw upon some of the recommendations we saw in the Nick Windsor report that was published last year into accelerating deployment of electricity transmission. However, this consultation goes much further beyond just transmission, and extends into proposed reforms to generation consenting procedures as well. The consultation is open now and does run until the 29th of November. A relatively short consultation, 1 month, which I think is indicative of the UK government's appetite to bring these changes into effect swiftly. It's also worth saying that not all of the changes that are proposed will apply to all projects that require consent under the 1989 Act. A number of the changes are focused on onshore projects exclusively and geared at optimising those arrangements. So if you've got a Section 36 application for an onshore wind generating station, a solar farm, a battery storage project, it's likely that a large part of what we discussed today is relevant to your project proposals. In the offshore environment, the position is a little bit more nuanced. In some cases, the consultation is very clear that the reforms will apply. Elsewhere, they say that certain new rules and procedures are geared at the sections of offshore consents that are on land. The consultation document doesn't specify exactly what they mean by that. However, we think that the best starting point really is to consider what is the red line boundary of your your Section 36, usually your Section 36 application for your offshore generating station. Does that encompass any land? If you're just applying for a Section 36 consent for an offshore wind farm, for example, the answer is probably no. However, if as part of that process, you're also seeking deemed planning permission for the onshore infrastructure, then potentially some of these reforms do apply. I think the overarching comment that I would make is that the application of these requirements offshore is more nuanced and project specific, and therefore it will be necessary to revisit consenting strategies as a consequence of the proposed reforms. If we could jump to the next slide. We can broadly split the changes into two categories: pre-application and post-submission of application, right through to the decision-making phase and beyond. I'll deal firstly with pre-application. I'll then hand you on to Jenny, who can talk you through some of the post-submission changes. So focusing first on pre-application, the headline really is mandatory pre-application consultation for Electricity Act applications. So whilst at the moment there is best practice guidance around that, this will now have a statutory footing. As I say on this slide, I think that's arguably somewhat inevitable when you look at other consenting regimes in the UK, across the UK, both in Scotland, town and country planning procedures for larger energy infrastructure, PAC applies, and the same principles apply south of the border, including on larger scale DCO projects where there is quite onerous pre-application consultation requirements. What's proposed as part of this consultation is really a hybrid of those two processes. So on the one hand, the integration of the TCPA PAC requirements, these are perhaps seen as much less onerous. So for example, giving prior notice of your application to the ECU or MD lot, publicising your application, there being a prescribed list of consultees, holding public events, which draws on the best practice guidance. Those will all be integrated now into these new requirements. I think what's potentially of more concern is the integration of onerous DCO style procedural steps. If I could just pick out three here, which I think are particularly worth paying attention to. First, there is proposals for a new preliminary information report. This is basically a report that needs to include information that is sufficient for consultees. This is wording lifted from the consultation document. For consultees to develop an informed view of the likely effects of the development. Now, you might recognise that wording because it's very similar to what is used in England in respect of preliminary environmental information, where there's a requirement on developers to effectively settle on a design envelope for their project in order to then carry out an environmental assessment during the pre-application phase. So that's potentially quite a significant change if that's now what's intended with preliminary information reports coming into effect. And it's much more onerous than what's required under existing town and country planning PAC regulations, where yes, there's an obligation to describe your project, there's an obligation to specify its location, but actually going that step further and providing a summary of the environmental effects at the pre-application stage, and that being sufficient to, as I quote, allow consultees to reach an informed view on the effects is potentially quite a significant new change. Now, you might think more information at the front end is a good thing, and I think that's a fair comment. However, there's no escaping that it is potentially very burdensome. It has significant programming implications, and in some cases, it might just simply be unnecessary. Developers, by and large, are doing quite a good job these days in terms of providing lots of information as part of their pre-application consultation, whether that's mandatory or not under a Section 36 and Section 37 process. And I think actually, arguably, the consultation slightly overstates what will be achieved by bringing in mandatory PAC. They draw on data going back to 2007 and say that frequently applications are being submitted without carrying out pre-application consultation, and that often planning authorities are actually just unaware of projects until the application is submitted, which I think slightly just disingenuous, because plainly in practice, developers are routinely complying with the best practice guidance. They're often mimicking TCPA type PAC regulatory requirements. There's EIA scoping, usually for wind projects. There's EIA screening, which is often the step for solar and battery storage projects. And there's these gate checks before you submit an application. So I think in reality, the assertion in the consultation that this will be transformative is perhaps slightly overstating things. The second point I wanted to draw out was the proposals for a statement of community consultation, or SOC, which is again a feature of the English DCO regime, where developers are obliged to set out in this new document how they intend to consult the community. They're also obliged, or the proposals in the consultation, is that developers also seek planning authority views on the SOC prior to starting their pre-application consultation. So I think the principle of that is okay. However, there are some potential risks in terms of, are you going to get that timely feedback from the planning authority? Are they going to ask for quite disproportionate consultation measures in the SOC, and therefore you have difficulty reaching agreement with them as to the scope of your consultation? So, for example, the geographic extent of the consultation exercise. And what this all feeds through into is this final step, this acceptance stage. Basically, there's now a proposal whereby applications may not be validated where they, I quote, fail to comply with the statutory requirements. So effectively, the ECU or MDLOT can say, no, we don't think you've complied with the requirements, we're rejecting this application, which again is a feature of the English regime. The issue, I think, is that compliance is not going to be black and white. What the consultation says is that the statutory requirements for acceptance will resemble what we have in England and Wales under the Planning Act 2008. So effectively, developers now might be obliged to pass an adequacy of consultation test. They'll have to persuade the EC or MDLOT that the application is of a satisfactory standard. So if that's what is proposed, again, these are quite subjective tests and potentially set quite a high bar for validation of your application. There's also a plan for the planning authority to have the ability to object to acceptance where it considers pre-application consultation has not been sufficient. So I think that's plainly a further concern. If a developer sat on their hands for, say, 12 months waiting on a response from the planning authority and decided to simply press the button on a planning application, on their Section 36 application, but then risks a hostile response at the acceptance stage from the planning authority due to them feeling there's not been adequate pre-application consultation. So I think just drawing this together, the principle of PAC, I think, is likely to be accepted, and it is somewhat inevitable, but it does introduce new consenting risks. And I think the elephant in the room is always back to this point that I'm sure developers experience at the moment in terms of getting that feedback promptly from the planning authority. And actually, is this really speeding up deployment in practice, or is it lifting what happens after you submit your application at the moment, and then you go through that exercise of consultation for 12, 18 months sometimes after the application is submitted. Is it just lifting that and moving it into the pre-application stage? And if that's the case, is it really getting projects consented and built any quicker? If we could jump to the next slide, I'll pass over to Jerry, who can talk you through some of the reforms post-submission of applications.
Thanks, James. Yeah, so looking then at the proposed changes to the application and appeals processes, central to the proposed reforms is the manner and pace at which statutory consultees engage with applications for Section 36 consent. Tying in with the sector deal and wider work on speeding up consenting for energy infrastructure, the proposals include ongoing activities which the government perceives as a route to improving engagement with statutory bodies. These activities include a forum with the ECU and statutory consultees to identify causes of delay in processing applications, developing a framework for delivering on applications, and provision of expert support to statutory consultees. Crucially, though, there are proposals to set time limits for each stage of the application process, including for the Scottish Government's determination and the contribution needed from each of the statutory bodies. Plainly, the imposition of time limits across all stages would provide greater certainty. The question is whether the government would in fact impose them. It's revealing that the consultation does not specify what these time limits would be, and envisages that the scope for these time limits could be extended for more complex applications. In reality, most Electricity Act applications are relatively complex, and as we all know, there are major resourcing issues with the ECU, Marine Directorate Licensing Operations Team, and statutory consultees. So, in our view, it remains to be seen whether the government is motivated to fix timescales in practice, and whether that becomes a statutory requirement is still not clear. So these proposals are aimed at resolving challenges for onshore applications, but this particular set of proposals does not exclude offshore and network applications expressly. There is also a proposal to restrict the point after which an applicant can request an amendment to their application, which will be determined on a case-by-case basis by Scottish ministers. This process is targeted at onshore and network projects, and on the face of it, geared at stopping developers making multiple changes to their applications, which, in the government's eyes, increases the burden on regulators and consultees. The concern here is that amendments can be a good thing. They are often aimed at addressing feedback from the planning authority. The concept of having a cut-off point is in principle reasonable in order to speed up decision-making and encourage developers to put forward realistic final proposals early in the consenting process. But the devil is in the detail. Specifically, when will that cut-off actually land? It would seem to be deeply unfair if it predates the consultation response from the planning authority. Developers will have spent considerable sums getting a project to that point, and should be afforded the opportunity to address feedback from key consultees once it's received, thereby avoiding a public inquiry, or, if there is a necessity for that process, ensuring that the developer has had the chance to refine the scheme and be confident that it can stand fully behind its final proposals in the event of an inquiry process. One of the potential criticisms of the proposed changes that James mentioned already is that it appears not to shorten the overall time it takes to get consent, but the time it is on the Scottish Government's desk. One of the other steps that the Scottish Government is taking with regard to onshore applications, specifically, is removing the automatic requirement for a public local inquiry where the planning authority objects. The proposed process would still require Scottish ministers to appoint a reporter where the planning authority maintains an objection, but the amended legislation would then give the reporter discretion on any further procedure, including deciding no further procedure is required, or they may instead specify that a site inspection, further written submissions, or hearing sessions are suitable. And the reporter would set target timescales for these procedures up to submission of their report to Scottish ministers. This could turn out to be a bit of a double-edged sword for applicants. On the one hand, no automatic PLI for onshore applications could speed up the application process immensely. At present, the average determination time for a non-PLI application is just over 2 years, whereas it's closer to 4 years with PLI. On the other hand, there could be a risk to applicants that they do not get the opportunity to respond to objections fully, where, for example, no further procedure is taken and the reporter believes they have sufficient evidence to make their decision. There is provision to mitigate this risk insofar as the applicant, planning authority and other interested parties can give their view on what procedures would be appropriate, and they can give it directly to the reporter or in a pre-examination meeting, but the reporter is not bound by this input. These changes could have a significant impact on the time it takes to get consent, but the risks that we've talked about just now involved in these proposals mean that this is a critical one to submit views on if you have concerns about how this might affect your project. Looking then at an interesting proposal that aligns onshore with offshore applications, the proposals include a 6-week statutory right of appeal for onshore consents under the Electricity Act 1989. This would do away with the 3-month judicial review challenge period for onshore consents, and as a result, onshore and offshore applications would be subject to the same period of challenge. The step of proceedings going first to the outer house with an appeal to the inner house of the court session will also be removed. Rather, the petition would go directly to the inner house, leaving only one further stage of appeal to the UK Supreme Court, where permission is actually very rarely granted. This is positive news for developers in that delays to their project post-consent due to legal challenges should be significantly shortened. This would have assisted some live projects, for example, Clash and Darrett 2, where the decision to grant consent was upheld by the outer house. However, further delays have resulted due to the petitioner's further right of appeal to the inner house. Under the new procedure, the inner house would simply have made the original decision, and if we assume that it would have also dismissed the petition, there would be no further right of appeal in the absence of a successful appeal to the Supreme Court. In short, this process should help projects reach a final investment decision and get spades in the ground faster without suffering undue delay with court challenges. So there isn't much time to delve into these last few points fully, but it's worth noting that there are also proposed changes to allow the Scottish Government to vary, modify or suspend onshore and offshore and network consents where there has been a change in environmental circumstances or technological changes, or there is an error in the consent. It's envisaged that this only covers negligible changes to consents, but it will be interesting to see how this is framed in the final legislation. And the proposed changes also introduce fees to allow the Scottish Government to recover costs of facilitating the pre-application process, which are not specified in the reform consultation document, although they would be based on the principle of cost recovery. And then lastly, there are a couple of proposals in the consultation document aimed specifically at network applications. So in addition to the pre-application requirements discussed earlier, DESNZ and the Scottish Government are inviting consultation responses on whether a multi-stage consultation process would be more suitable for network projects. We expect the aim is to provide for the nature of linear projects that require input from stakeholders across a large stretch of land, multiple planning authorities and different landscape types, but we're waiting on a bit more information about this. A variation procedure is also proposed for varying network consents, which reflect the existing provisions for generation stations under section 36C. And lastly, DESNZ and the Scottish ministers are looking to introduce fees for necessary way leave applications to cover the cost of processing and administrating the application. This is a big download and we're nearly out of time, so I'll hand you back to James to run through a few key takeaways from today's session.
Thanks, Jerry. So what does this actually mean for your projects? I think one of the key things to focus on is the transitional arrangements. At the moment in the consultation, these are very simplistic. Effectively, if you're halfway through the process of securing consent, you don't need to go back and retrospectively carry out any new requirements. But anything that lies ahead of you in the consenting journey, there is an expectation that you comply with those requirements or are subject to those new arrangements. Some good, some potentially more challenging. Pre-application consultation, I think there is going to be a necessity to think about strategies around pre-application consultation as a consequence of these reforms. Do you go fast, effectively finish pre-application consultation activities and get your application submitted before these new procedures, including an acceptance stage, come into effect? Or do you go slower and actually wait and see what's proposed and don't actually invest those resources and time until you have certainty that the pre-application consultation you carry out is going to be compliant with the new requirements? I think the other thing to mention is the fundamental objective here is to align pre-application consultation with some of the DCO requirements down south, as was expressed in the Nick Windsor report last year. So in that sense, we do have some visibility of what's coming here and some understanding of what the final regulations may look like. And therefore, there is potentially some visibility available to developers now in terms of the requirements, and therefore some opportunity to future-proof your proposals as a consequence of that. For offshore developments, going back to what I said at the start, I need to revisit consenting strategies around that. Do you have do you split your planning permission or your need for consent for the onshore elements of your project into a standalone town and country planning application, thereby potentially avoiding some of the more onerous elements that would have otherwise been caught by making a request for deemed planning permission as part of your offshore Section 36 application? So there's some things to think about around there. I think it's worth acknowledging that there are some positive changes as well. The principle, at least, of fixed timescales, speeding up consultation responses, speedier judicial review proceedings where they're necessary. You know, these are in principle good things. What we do know is that the time to influence these proposals is now. There is 3 weeks left of the consultation. So I think it is incumbent on developers to review these proposals and think about making their submissions in terms of what actually would facilitate new development rather than potentially frustrate it. If we go to the final slide. I'm conscious that's just about our time up. So firstly, thank you very much for listening. I hope you found today's session useful. This was obviously very much a whistle-stop tour of the headline changes set out in the consultation, but by all means do reach out to us if you have any project-specific queries. There is just time to let you know that Jerry and I are planning to host a further in-person event early next year, reflecting on 2 years of MPF4. So around February time is the plan, which aligns with the adoption of MPF4 in February 2023. I'm sure some of you may have seen my updates on LinkedIn, having your feeds potentially clogged, usually on a Friday when the ECU issues a new Section 36 decision. So we're quite keen to take that step further, close the laptops, turn off the phones, and meet as many of you as in person, really, to reflect on decisions over the last 2 years, the application of policy, and really give a download on the key takeaways and what that means for future projects. So we'd be absolutely delighted if you were keen to join us for that session. This session is recorded, so you'll receive a copy of the video, and you'll also receive a copy of the slides. And alongside that, we will include a link for you to register your interest for the 2 years of MPF4 key decisions session that we're planning on hosting in the new year. So we'd be delighted if you were up for getting involved in that as well. So yeah, otherwise, thanks again for listening. Really appreciate your time and enjoy the weekend when it comes. Thank you.